SJC-13182, Commonwealth v. Jorge Vega, and another.
Attorney Garland, welcome.
Thank you. Good morning, and may it please the court. Our case rests on two basic premises. First, Section 58A's departure from ordinary constitutional principles requires that it be limited to a few extremely serious crimes, those that have the menace of dangerousness. Second, following Young, regulatory firearm possession charges, without more, lack that menace of dangerousness. Therefore, firearm possession charges, as such, cannot be predicates for pretrial detention under Section 58A. And that doesn't mean that firing a firearm, brandishing a firearm, illegal use of one, or possession of a firearm with intent to use it for some illegal use. All these things could be proper predicates, either as freestanding crimes or as sort of non-categorical predicates, as in the abuse clause discussed in the Sioni case. But simply,
does Young sort of assume, without getting into it, that this enumerated offense would be constitutional if there was clear and convincing evidence?
If there was, I mean, I guess the clear and convincing evidence, I guess, gets to the second stage. I mean,
no,
so
I understand, and it's enumerated. I'm just asking you if there's dicta in Young that suggests the constitutionality of this offense.
I mean, I think Young footnote 11 certainly suggests that the legislature could add at least some form of it. It obviously doesn't address the constitutionality directly because it results, it's a statutory decision ultimately. But footnote 11, I think, does suggest the legislature could do something. And we do suggest that this legislature could add some form of predicate. We just think this is too broad and therefore it defeats narrow tailoring. And I think the ultimate issue is in some ways less about firearms and more about 58A itself. And I think the decision in Mendonca—
Before you leave that though, so they don't make a predicate offense possession in the home or possession in your business, but they do make carrying the firearm. Isn't that narrow tailoring? Shouldn't we respect that?
I agree that's some tailoring. I would suggest that's still not enough because many people do carry firearms, even unlicensed people, for their own protection. And the Commonwealth, which, because we're in strict scrutiny here, the Commonwealth has the burden of proving that that's not the case. And my belief is that there are a large number of people out there that it may not be a good idea, and the legislature can punish that, but they don't necessarily present the menace of dangerousness such that the legislature can bypass.
Mr. Garland, is there a gun violence problem in this Commonwealth?
Absolutely. And again, I think the legislature—
all right, then absolutely, then why not? I mean, what if we agree with Justice Cowan's analysis and her dissent, and we say that if you look at the factors she cited, we get past strict scrutiny? How do we not use this to address the epidemic of gun violence, especially in the inner cities?
I absolutely agree that's a problem. And I absolutely think the legislature, when it comes to punishing crimes, setting crimes and punishing them, the legislature has a large amount of deference. It can sweep a lot more broadly. And it can say, even if you don't have any particular bad reason for carrying this firearm, even if you are just carrying it for your own self-defense, tough luck. You know the law, even if you don't know the law, but most people do, you can't possess a firearm without a license, and, you get punished. But that's different. I think it really gets to this point about Section 58A, that Section 58A is a deviation from normal constitution.
No, I know why you want to get to 58A and the strict scrutiny. I agree with you 100% in why it's a deviation. Did you look at the Federal Detention Act that also includes detention for possession of a firearm?
It does, and we cited that in the footnote in our reply brief. Footnote, I'm blanking on which footnote. I think
the footnote number doesn't matter.
Yeah. So, the federal statute. For one thing, there is no federal licensing scheme. So most of those cases are going to be felon in possession.
Okay, but by its terms, it says possession of a firearm. Have there been due process challenges to that provision in the federal statute?
Not that I'm aware. And
Did
I would
you-
also note that
Did you look?
I have looked and I have not found any. I've not done a, I've not looked at every case ever addressing the federal statute, but I did look for, due process type issues. I didn't find any.
All right, thank you.
And I would also note that the federal courts apply a lower standard, at least in some cases, of substantive due process analysis. And so I think that even if federal courts had upheld it, even if the US Supreme Court would upheld it, this court's jurisprudence under Articles 1, 10, and 12 is still stricter than that.
Attorney Garland, if I could follow up with on Justice Gaziano's point. Obviously, one, it's nice to see you and Attorney Slyman, who we'll hear from in a moment, because the three of us were together in Dorchester for a long time. And that division in Suffolk County has the highest number of gun cases in Suffolk County come out of that division. All three of us know that. And these are the people that live in these neighborhoods that we care about. And when you talk about the fact that there may not be anything per se violent, or that there may not necessarily be a violent purpose for why they're carrying or you find these unlicensed firearms, but we see them in all the 1-1s. You hear all the shot spotters go out every night, where the good people of those neighborhoods could get a good night's sleep too. And that the cars that being stopped with all the unlicensed possessions of firearms. I understand that Justice Cowan was the dissent, but I still, barring the occasional person that might be going through Commonwealth of Massachusetts from New Hampshire, why isn't it that we could say it's in and of itself that you wouldn't be carrying that unlicensed firearm if you weren't going to do something wrong with it? Why is that so hard a premise to say the legislature could then say, because of that, we just don't want that in our neighborhoods, and leave it to the second part of 58A to see whether or not there's any reason to hold this person?
I mean, I think the legislature can do that as a matter of setting the law and punishing people. I mean, I think the bigger picture problem is that, the bigger picture problem, of course, is that Section 58A really does have to be cabined narrowly. And then the other problem is that, the neighborhoods where there is the most risk of gun violence, there's also the most need for self-defense. And, a lot of people are going to end up carrying firearms for defensive purposes, even if they don't have a permit. And the legislature can punish that. The legislature can say, that's a bad idea. We don't like that. We can punish you for that. But that's still different from saying that we can detain you sort of in contravention of normal constitutional principles.
But leave it, take your point though. I mean, isn't that in and of itself dangerous, that somebody's arming themselves for purposes of self-defense, and rather than walking away or de-escalating a situation, they'll pull out a gun and shoot? How does that the point?
Yeah, but self-defense, I mean, and again, I think the legislature can say that is a bad idea. But I think that's still different from that being so dangerous that we need to bypass the Constitution to deal with it. And so, and I think it gets to, Justice Freed's opinion I find very thoughtful in Mendoza, where Justice Freed, as Solicitor General, had argued for pretrial detention in Salerno, and he comes back and he approves it in Mendoza, the court does, but they're very troubled by it. And there's this concern that if we make this widely available, that we're going to bypass sort of the normal principles of the Constitution. And maybe it's not going to happen today, maybe it's not going to happen tomorrow. But eventually this is going to keep growing, and eventually this is going to replace a lot of the normal constitutional processes we have for dealing with these problems. And if we make it too widely available, I think there are a lot of people who in absolute good faith are going to say, let's use this to solve these social problems that are absolutely real social problems. And it's going to sort of take the place of these principles that are very important and enumerated in the Constitution, in great detail.
But if it solves the social problem, doesn't it then provide a basis to satisfy strict scrutiny.
Well, I mean, it solves some social problems. I mean, one issue that
I mean,
think-
I'm not getting your OK Corral analogy that we're just going to throw our hands up and allow people to be armed. But speak to whether or not it survives strict scrutiny, given the gun violence issues.
And I'm not saying that, again, I think the legislature can say we're not going to have an OK Corral scenario. We are going to punish people who violate these laws, even if they had absolutely innocent intentions in violating them. Because
as Justice George has said, I mean, the parade of horribles about the old lady cleaning out the Ruger from the World War II veteran who's taking it to the police station, that's just nonsense. You know that. So deal with the realities of gun violence.
Well, there are cases. I mean, these are not those cases, I acknowledge, but there are counties in which prosecutors pretty much as a rule, even if an informal one, apply in every single case. They may not necessarily get held for the full 120 days, but even getting held for 3 days. The Dobby study we cite at pages 24 and 25 of our brief talks about how the test that they do for all these harms that come from pretrial incarceration is do you get released after 3 days or not, or before 3 days or not? And so all those harms, you can lose your job, and that ended up being destabilizing. And what Dobby and the Leslie and Pope article we cite also say is that, yes, when you detain people pre-trial, you can get a short-term reduction.
No, I know. I agree with you, and I agree that it has to be strict. That's why we have strict scrutiny. The government doesn't really address that. And Mendoza and Amy and all those cases absolutely say we have to do this in the narrowest of circumstance. But what we're puzzled with, or I'm puzzled with, is why it doesn't satisfy strict scrutiny when we have this glaring issue of gun violence in this Commonwealth.
And
I think I read something this morning that said 91% of the fatalities of young people are from firearms.
I don't know. I mean,
It
maybe
was in the Globe, so maybe it was wrong, but I read something this morning.
I mean, I think that would be higher than I would. I mean, I don't know, but I agree with the court that it's a big problem, and the legislature does have tools it can use, including criminalizing unlicensed, even innocent unlicensed possession. But again, I think it goes to this sort of fundamental problem. Blackstone famously said, better 10 guilty persons go free than one innocent suffer. And Section 58 kind of turns that on its head and says better that 10 presumed innocent people suffer to prevent one person from causing some harm.
But Mr. Garland, that's not sort of getting at the key point. There's no doubt that preventative detention raises serious concerns because the individual hasn't been found guilty beyond a reasonable doubt yet. That's a given, and that's why Salerno and Amy and Mendoza all require strict scrutiny. But when you mentioned earlier that you believe that the Declaration of Rights provides enhanced constitutional protection here, presumably on the procedural due process and substantive due process side, what specifically are you referring to? Because I like Justice Graziano, I'm not aware of any case at a United States Court of Appeals level, at least saying that felon in possession or firearm offenses don't fit within the federal statute and wouldn't survive strict scrutiny.
Right, and again, that hasn't been addressed. And I would suggest that felon in possession, at least that would be, if that could be something that they could really tailor.
My question was too long that you forgot it. What specifically is it that you're referring to in our case law that says that cognate provisions of the Declaration of Rights provide enhanced protection in our strict scrutiny analysis?
I mean, Mendoza gets into that a little bit. And there's, I mean, for instance, as a procedural matter, the detention of the mentally ill and dangerous under.
Just let's be clear, this is a substantive due process claim, correct, Mr. Garland?
Right. But I mean, but connected to procedural due process, and I think we challenge both. And so I think Mendoza gets into this, that the Articles 1 and 10 provide more protection. And so for those reasons, I asked the court to reverse the single justice and hold that Section 10A cannot be a predicate.
Can you just follow up on what the answer you gave to Justice Lowey? Why would felon in possession, which is also a regulatory crime, it has to do with one's status, have more teeth to it than just regular old possession?
I mean, it is more narrow. I mean, for one thing, I mean, the federal cases, again, they don't address the constitutional issue. There actually are a number of federal cases we cited, Singleton, Lane, that say that under the federal equivalent to the residual clause, that those were not enough. So it does have some of the same problems, but it is also more narrow.
But there was a federal split over whether or not it satisfied, similar to Young, correct?
Right.
But then the feds amended their statute, in my understanding.
Exactly.
Okay, thank you.
Thank you.
Attorney Slyman.
Thank you. Good morning, and may it please the court, Mackenzie Slyman, arguing on behalf of the Commonwealth. When the legislature amended 58A to include the unlicensed carrying of a firearm as a predicate offense, it did so not only as a lawful exercise of its inherent police power, but also in direct response to the authorization essentially provided by this court in Young. This court acknowledged in Young that whereas in the situation we're in here, the elements of a felony do not require proof that the defendant actually disregarded the safety and well-being.
Young says nothing about substantive due process, correct?
Correct, Your Honor. Young doesn't get into a strict scrutiny analysis. Young was analyzing 10A solely under the issue of the residual clause, whether it fell in there, finding that it didn't because there was no substantial force in relation to the elements of that chart of the offense. The court could not fit it into that clause. But I think it's really important to point out there that I think the court made it abundantly clear that they had to reach that conclusion due to the nature of the residual clause, which was later struck as being unconstitutionally vague, but that absent clear legislative intent to the contrary, they were stuck essentially with the language that they had in front of them, and that the court recognized then that there are dangers related to unlicensed firearms. And I think we've spent a lot of time talking about this language of menace of dangerousness. This language only comes out of Mendoza. It's not taken from Salerno or any other authority. And there it's.
Well, it's a danger. I'm sorry. Go ahead, Justice Georges. I'm sorry.
Thank you. If I could just interrupt you for one quick question. Even though in Young it was being analyzed under the residual clause, and then it was subsequently enumerated to now be one of the enumerated crimes, does that at all change the court's analysis and application, though? Because even though now it's a predicate offense, does it change the court's analyses that the nature of simple possession of a firearm isn't one that involves the type of force that we ought to be concerned about, or threat of force that we should be concerned about for purposes of 58A?
I think it does, and I would point to footnote 11 of the Young decision, because I think there the court recognizes that where the elements don't have that requirement of proof of safety and well-being, where there isn't that very obvious connection of a disregard of safety to others, that the making that determination properly lies with the legislature. So I think once the court weighed in on this in Young, the legislature then took it, evaluated the situation, and came to their own conclusion and exercised their own judgment in finding that unlicensed carrying is in fact dangerous, so dangerous that it should be that it should serve as a predicate for moving for dangerousness detention.
Did the elements change before and after Young of
No.
simple? It didn't. And we said in Young that rather we look to the facts, rather than look to the facts of the particular case, we look to the elements. So the legislature might have done what they did, but I guess I'm going back to the heart of what we did. If the elements hadn't changed, and it's the same elements that we are to look to now that it's an enumerated crime, what's changed about the application of our analysis from the majority in Young to now?
I think what's changed is that there isn't a requirement that the court be looking solely at the elements of the crime and determining whether or not the offense is in fact dangerous. And I think that this can also be looked at if you look at the other enumerated offenses within 58A1. I would point out that it does also include violations of the Controlled Substances Act and OUI third offenses. I think that those are examples there too, where you can look at those the elements of those charges and not find any force showing where you needed to find force. And so I think that it shows that there isn't a requirement that we only be looking at the elements. And I think, Justice George, this is what you were alluding to further, that gun violence is without a doubt a huge problem in the Commonwealth at large, and specifically in the city of Boston. At minimum, it causes a nuisance to the communities we live in, and at its maximum, it's taking lives from everyone. And this provides a tool for the legislature, for the judiciary, and for the executive branches to step in when someone doesn't have a license to carry a firearm and take that firearm out of circulation, and recognize that person could use that firearm in a dangerous manner.
So, so I'm sorry, did you finish your answer? I'm sorry.
Yes.
So two questions. One is, did you look at the federal statute and the case law?
Yes.
You did. All right. What did you find? Because I don't think it's in your brief, unless I missed it.
I did touch on Salerno. I think so far as it.
No, I meant the federal. I meant the federal detention statute.
Sure. So I'm not sure where the court's question is going specifically. I acknowledged at the time that Mendoza came out when it was comparing it to Salerno, or I suppose when Salerno came out, that the possession of a firearm wasn't included as a predicate offense at that time, but that it has subsequently been included as a predicate. But I think that the Supreme Court's analysis there is still applicable here, that it is a sufficiently serious offense.
All right, let me ask you about the Alvarado decision. If you recall, the Alvarado is a search and seizure. Alvarado is a search and seizure case that says that just because you have a firearm doesn't mean you have a right to search someone, right? So having a firearm is not illegal. Having an illegal firearm is illegal, but it speaks to the inherent dangerousness of the firearm in this regulatory offense, as Mr. Garland writes in his brief. What do we say if we say that this is inherently dangerous and it satisfies strict scrutiny? What do we do with Alvarado, where we said it doesn't?
I think that the stages of investigation and the trial process are different there, and I think that's where this distinction can be found. I would look at it as well, discussed in Jackson as Commonwealth v. Freed, where in Jackson, I think there's a lot of really helpful discussion in Jackson from this
Can you
court.
explain the first part of that answer again? I don't think I followed what you meant.
Sure. I think the difference that we're looking at here is that the analysis that the court's doing when it's with the dangerousness hearing is we're only looking first at it's not just only the possession of the firearm itself, it's the ramifications that surround it. I think that distinguish it from Justice Gaziano's question. And I don't know, perhaps if
but I guess the question we have is, doesn't that sweep too broadly? Because dangerousness is supposed to be very rare and very unique and that's why we have strict scrutiny. My concern is this sweeps too broadly.
I understand. I think it still is narrowly tailored, and I think it does still surpass the strict scrutiny analysis because of
narrowly tailored to what?
To the dangers that are inherent to unlicensed carrying of a firearm. I think this was touched on with Attorney Garland, that there is a difference between possessing one.
But now it's your turn to answer, not with Attorney Garland.
Of course.
So the questions he raises some really important issues in his brief, whether or not just sweeps too broadly, and whether or not this is just an overuse, an unconstitutional use of a preventive detention statute.
Sure, I don't think it sweeps too broadly. I think the legislature indicated that it was thoughtful in its choice of what sections to include as predicates. I think there is a distinction to be drawn from possession without an FID card in your home or in your place of business. I think there's a difference between having, a firearm in your nightstand that never really leaves your nightstand than actively carrying one out in public. That poses an inherently a greater risk towards the public and towards the community of danger. And I think that's exhibited through this court's acceptance of the increase of mandatory minimums on possession of the firearm during the commission of a felony, where the mandatory minimum is increased there, and really having a firearm on your person, because I think it illustrates there that there's an increased risk of danger in that situation by merely just having the firearm with you. The fact that there is a mandatory minimum that's associated with 10A of unlicensed carrying, where there isn't that mandatory minimum on 10H of unlicensed straight possession of that firearm. There's repeated acknowledgement that there is the danger that is associated with carrying in public these unlicensed firearms, because you're circumventing the system we have in place to be checked for a license, to go through the safety training, to have your criminal record examined, to make sure that you are fit to be carrying in public a very, very dangerous weapon.
A lot of states don't have these requirements. A lot of states are so-called constitutional states where there's a right to possess a firearm, right? So this puts us, this regulatory scheme that you speak of is in the minority of states.
That's correct, but I don't think it oversteps the legislature's ability to make this requirement for people. I think it's taking into consideration the significant risks of firearms in public and the prevalent issue of gun violence, and it is not overstepping in that regard.
Does the strict scrutiny analysis apply to the scheme entirely, or to these gating enumerated offenses?
I'm sorry, and I didn't hear the last part of the question.
Does the strict scrutiny analysis apply just to the enumerated offenses and whether or not the offense is on the list? Or is it an analysis that takes into account the entirety of pretrial detention?
I think in the case we have before the court today, I think it would be the former. I think we're looking specifically at where the defendant is challenging the inclusion of 10A as a predicate. I think we are.
Why would that be? Because that's not enough to hold somebody. You've got to do the
Sure.
clear and convincing evidence that there's no conditions or combinations of conditions of release. I'm not sure I understand the answer to Justice Wedland's question, actually.
Sure. So I will step that back. So it would apply to the entire statute, and I think when you look at what the test is for strict scrutiny, we're looking at that that it's narrowly tailored to a compelling government interest, but also that it's least restrictive means. And I think that part of the test, least restrictive means, is what expands it to the entirety of the statute. And the Commonwealth does go into that in its brief, that by the nature of the statute itself, it embeds in it entirely that there is that on a case-by-case basis on every single person that's brought in front of the court on a dangerousness hearing, the court needs to determine every single time that this is in fact the least restrictive means, that there is no alternative.
Doesn't that beg the question though? So if we only rely on part 2, we just throw our hands up and say you can do anything on part 1 for the predicate crimes?
I don't think so. I don't, because I think that the legislature would still have to pass in the interest of, or include something as a predicate in the interest of some compelling government need. I don't think that
isn't it part of the tailoring process? Because you can't include certain crimes. So you start the narrowing, the funneling down in the first part with the definition of the predicate offense, and then you further tailor in the second part. So it seems like it's part of the least restrictive alternative. It's a 2-part analysis, right?
Yeah, I would, yes, I would agree with that, Your Honor. I think they inherently flow together.
Okay, shall we give Attorney Salwa a chance to answer questions?
Thank you.
Let's do
Thank
that.
you, Your Honor.
Thank you.
Morning, Your Honors. May it please the court, Abigail Solois on behalf of the Commonwealth. My sister has covered most of my arguments, so I won't take too much time. And of course, I'm happy to answer any questions that you may have. But where I'd like to begin is to the point that the pretrial detention statute in Massachusetts is narrowly tailored. The statute only allows the Commonwealth to move for pretrial detention. And then, of course, the Commonwealth has to prove by clear and convincing evidence that no conditions of release would reasonably assure the safety of others. And looking at the facts of this case in particular, Justice Hanlon correctly denied the defendant's petition for relief. So after the Commonwealth is able to move for pretrial detention, the judge, it's not a free-for-all. There are 12 factors that are enumerated in 58 sections.
Let's talk about the first factor, though, the predicate
Sure.
crime. You can't, unless I'm mistaken, you can't detain someone on first offense OUI, right? It has to be
No,
a third offense.
Absolutely not.
Third offense or something, right?
Yep.
But
Third and subsequent.
okay, but you could argue that a first offense OUI is just the first time the person's caught and they're a danger because they're endangering the safety of driving public, right?
Well, the legislature
And then you would answer, well, we have part two, and you have to jump through all the hoops. So, but I think you have to show why the enumerated offense satisfies strict scrutiny.
So the legislature in adding this, well, actually, let me take that back a step. So in 2019, when the residual clause was held unconstitutionally vague, the statute, of course, became much more narrow. So right now, the only enumerated offenses under 58A are burglary, arson, whether or not a person is put at risk thereof, domestic violence offenses, witness intimidation, OUI, third and subsequent, some animal abuse offenses under the ACCA, and controlled substances punishable by 3+ years. So the first part of the determination is whether or not it's one of those enumerated offenses. And then if it is, it's then the Commonwealth's burden to look at the specific factors of the case and go through, for example, the circumstances of the offense. So in this case,
Counsel, there's a problem here. And I guess it goes back to Attorney Garland's point. I don't know about you, but I've never been held in jail, right? And if you're saying as a predicate offense that this is okay, it's as of right? The judge doesn't even make a determination about whether or not ultimately the person will be detained. It's the Commonwealth moves and you say, hey, judge, you've got no discretion to not hold them pending a hearing.
no, respect for your honor, that's not how my understanding of how the statute works. So first, the Commonwealth makes the enumerated offenses just allow the Commonwealth to move for dangerousness.
Right.
And then there's a hearing.
You get 3 days.
You've got 3 days. So
well, we can move for a continuance with the showing of good cause for 3 days.
You're missing the fundamental predicate though. When you move for dangerousness and say it's one of the enumerated predicate crimes, are you saying that the judge has discretion to say, no, I'm not going to hold?
After a hearing, they can determine that there's not clear and convincing.
That you move for dangerousness.
No,
Okay,
of course.
But that's what I'm getting at.
Okay.
So if you're holding anyone for any amount of time, that's a big deal. And we've said that a lot of times, that it's a big deal, right?
Certainly, Your Honor, and I don't mean to diminish the importance and certainly the problems associated and the harms associated with pretrial detention. I certainly am not blind to those things. However, I would say that the harms of gun violence in the city and in the Commonwealth far outweigh the harms of a limited, I'm sure one day in jail, as Your Honor said, is awful. However, I would argue on behalf of the Commonwealth that the harms of gun violence far outweigh those. And going to, the stated purpose of firearm legislation is to limit access to deadly weapons by irresponsible people and preserve public health, safety, and welfare. And looking at the wordage used in the Young case, the court did not express reservation or suggest limitations regarding the inclusion of 10A and 58A. It didn't say, well, we should only do it if the firearm is brandished or used, and maybe these, it said that were not unmindful of the dangers relating to unlicensed possession of firearms. And certainly in Justice Cowan's decision, there was some very, heartfelt words about the risk associated with firearm possessions quite clearly are increased when the firearm is unlicensed. And the purpose of a firearm is to injure or kill. There is no other reason for that weapon's existence. So I would say that although I'm sympathetic to the harms of pretrial detention, it's far outweighed by the problem of gun violence in the Commonwealth. And the statute affords,
Counsel, is that the test? I guess, isn't the test whether holding somebody for 3 days is a narrow tailoring to achieve the compelling state interest in these enumerated crimes and holding somebody to then have the hearing to evaluate whether to hold more broadly. So it's really the 3 days. Is 3 days narrowly tailored to the potential danger posed by somebody accused of these crimes?
Yes, Your Honor, I would argue that the 3 days is outweighed, and that's why it's limited to these offenses, and there is no more residual clause, and it's become much more narrow since 2019. I would also point out that the debate about the constitutionality of pretrial detention has been going on in Massachusetts for decades, and a close reading of 58A and the history of the statute shows that the legislature and this court have struck a very careful balance between public safety and the constitutional rights of the individuals who are charged with these particular offenses.
Counsel, along those lines, may I ask you, how much is the judge permitted to take into account when making that evaluation, the level of gun violence in a particular area at any given time? Or is the judge confined to the defendant's circumstances?
The first factor under 58A Section 5 is circumstances of the offense. So I think you can consider that, yes. So for example, in this particular defendant's case, the police responded to a call for shots fired around 1 o'clock in the morning in a high crime area of the city of Worcester. They arrived to find a person who was injured and said he had been jumped by a group of males. And then the police came upon a group of males in the parking lot in a vehicle with a loaded stolen firearm. So there's no question in this case that this individual was dangerous. This is not a case where it's a little lady moving an antique firearm or an over-the-road trucker driving from New Hampshire.
Well, are there not federal provisions that would protect the trucker through interstate travel?
Yes, I mean, there's certainly different jurisdictional questions that would come up in that set of facts. And to my knowledge, that's not something the Commonwealth would move for dangerousness on. I don't spend much time in the district court, but my understanding is that's not something the Commonwealth would move on. And even if it did, I can't imagine a judge issuing a pretrial detention order on those set of facts.